I think a lot of the infringement by large companies is innocent at first, in the sense that, and I've been at Microsoft for 15 years, I know how large companies work. There's usually a memo that tells people don't look at third-party patents because we don't want to be in a situation of willful infringement. So people are flying blind for the most part and reinventing what others have done in many, many cases. And then they're being told that they infringed because they reinvented the same darn wheel. So the predatory aspect is not in terms of going out and looking for something useful and then they'll say, oh, we'll copy it. The predatory aspect is when they decide that they're going to use the system to essentially not recognize other people's IP rights. And that's the part that is really detrimental to the U.S. economy.
Hello, I'm Bruce Berman, the host of Understanding IP Matters, the critically acclaimed podcast series that provides leading innovators and experts a space to share their IP story. Learn firsthand about the strengths and weaknesses of copyrights, patents, trademarks, and trade secrets as they adapt to an AI-driven world. This is our 4th season. Louis Carbonneau is one of the most astute observers of the innovation and technology landscape. He ought to be. As a patent broker, the buyers and sellers he represents are typically interested in strengthening their defense or generating revenue. As the founder and CEO of Tangible IP, Louis has brokered the sale or license of over 5,000 patents, returning tens of millions of dollars to patent owners and inventors. His monthly newsletter, IP Market Updates, is read by over 20,000 IP and business professionals worldwide. A former Microsoft licensing executive, Louis is a venture partner in Cycle Capital Management, a large clean tech venture capital firm with over 600 million under management and 43 investments. He is also an inventor himself and holds U.S. and international patents. Welcome back, Louis, to Understanding IP Matters. You were here before last year, and we're bringing you back to give us an update. It's good to see you again. Where are you speaking from today?
Always a pleasure to be with you on this. I'm actually speaking to you from Seattle today.
Let's get right into it and see your assessment of the marketplace is usually spot on. So, it's really helpful for our listeners. How would you assess the current landscape for patents?
It has been a buyer's market for almost a decade now. There's no doubt about it. That has not changed, I would say, conceptually, because there's first more supply than demand. And as we all know, if we listen to your podcast, the Alice has done some carnage in terms of patent eligibility, and the PTAB has been the other shoe to drop in the last 10 years and has invalidated issued patents at a rate of, roughly 80%. So because of that cloud over validity, obviously there's very few patents that will be transactable. Having said that, and we are, as you mentioned, we are in this day-to-day, every day, and we have seen quite an uptick in the last 12 months, I would say, in terms of buyers' interest. The market seems to have found a way to make this work despite all the obstacles. It's kind of built in the formula and the valuations, obviously, so is not as profitable as it used to be maybe 8-10 years ago, but there's certainly a lot of activity.
What are the industries that are kind of hot these days where you can actually get a clear pricing and a purchaser?
In a sense, it's not technology driven. It's really patent driven in the sense that, people will start from, you have to have claims that are very strong and you have to have a very clear and unequivocal infringement read. It starts from that because, 99.9% of the patents that we sell for their assertion value, meaning someone needs them because either they're infringing or a competitor of theirs is, or they are in the business of monetizing patents, like non-practicing entities. So it starts from, very strong infringement read. Then people, if they like the read, which is kind of the starting point, they look at the validity, obviously. They want to make sure that, there's no prior art. So there's a lot of prior art searchers that go into the process. And then they don't want this to be a high Alice risk, meaning, claims that are abstract ideas. Once you've passed these hurdles, then it's about damages,
But clearly, like the semiconductor industry seems to be pretty hot these days with NVIDIA as a company doing so well. Are semiconductor patents still in demand, or are they valued higher?
There definitely are, and they are normally valued higher, mostly because they don't carry that one-on-one or Alice risk for the most part, unless there's software, patents on the fridge of semiconductor applications. So yes, they will be usually transacted at a higher per patent price than your run-of-the-mill patent.
What are they going for these days? Is there an average?
Again, that goes back to the point that I was making. It's all predicated on recoupable damages. So if it's a brand new chip that's just starting to sell, the value won't be that great, because if you sue someone, you can only claim past infringement. You cannot change the past. And if the infringer designs around or changes, the infringing product and stop infringing, then there won't be any future damages. So because of that, the value could be very low. So what you want to go to is basically patent that have been infringed for quite a while. That's where you have these accrued damages for the 2, 3, 4 up to 6 years. So because of that, although they do transact at a higher valuation most of the time, it will change. It will vary greatly depending on whether this infringement has been going on for a while. The other counterpoint is that it's a lot harder to detect infringement of semiconductor patents, and certainly a lot more expensive. You have to do tear down, you have to buy those reports, industrial reports that cost a lot of money. So as a result, they're just, I would say, much smaller pool of buyers.
So effectively, you have to buy the allegedly infringing product and tear it down, like reverse engineer it to determine what's in it, really.
Yeah, I mean, in essence, yes, although you do this indirectly by buying a tear down report that someone else did. So because there are firms that will do this, they have the right clean room equipment, and then they will sell this report to people who want to have the tear down, and then you have all you need to do your claim chart. Otherwise, it would be extremely expensive to do it from scratch unless you have the facility, indoor. If you get there and you have an infringement on a Qualcomm chip or a Samsung chip that is widely available in products, then yes, you do have something that is extremely valuable. But we're talking about really the tip of the iceberg here.
What areas are less attractive, would you say, like algorithms and software, which is questionably patentable at this point?
Yes, because of the one-on-one risk, anything software is obviously scrutinized more carefully before people buy them. Having said that, most of the patents we sell have some software angle in them because there's so many of them in circulation first. But obviously, you have to look at how they were drafted, how the spec was drafted. So in a sense, it's a quandary, because the best patents are usually 12, 15 years old, like good wine, because the industry has caught up, there's some damages, and because they're older, there will be less prior art. But if they're 12 or 15 years old, it means they were drafted in the world pre-Alice. So people didn't know what they didn't know at that time, and they did not know how to draft patents to traverse some Alice arguments. So the specs sometimes are a little bit thin in detail, in technical detail, and the figures are maybe a little bit too sketchy. So if you were to write the same patent today, you could actually make it more Alice-proof with the same invention, but you didn't know that 12 years ago before Alice. So, we have a lot of patents that are great in theory, but will fall prey to Alice because of the way they were drafted before that.
You can't do a 15-year continuation.
You can do a continuation, but you're limited to the same spec anyway. So and if you do a continuation in part and you add some new subject matter, then in all likelihood, the new claims that you will get will be based on the new subject matter. So then the priority date will be the one of your most recent filing, which means that all the intervening prior art will be relevant. And it's very likely that although you might not have an Alice risk, you will have a prior art risk.
Many unicorns, Louis, private technology companies whose value exceeds $1 billion, they seem to care less today about patents, opting for stronger trademark, trade secret coverage. If they're software, e-commerce, or internet companies, and we alluded to this earlier, the patents don't seem to mean very much because of Alice. To what do you attribute this trend towards weakened patents, and to unicorns feeling, well, we could do without the patents?
Well, the unicorns are, obviously funded by VCs for the most part, and a lot of them in Silicon Valley. There's a current thinking in Silicon Valley that, frankly, because it started from there, that patent rights are not what they used to be, because most of the Silicon Valley behemoths there have been applying themselves very well for the last decade and lobbying to weaken patent rights because of their efficient infringement model that, they prefer to taking a license every time people knock at their door. So as a result, I would say it's permitted, the thinking in Silicon Valley that, patents are not that important anymore, and that, you can do without them. The second part of that is that a lot of VCs, are interested in flipping companies after 2-3 years of their investment. So their exit is going to be 3 years, and it takes 3 years from filing to issuance of a patent on average. Even if they did believe in patents, they wouldn't change much, because by the time they want to exit, there wouldn't be anything on the table that's issued, or very little. So that takes it off the table a little bit in terms of the strategic thinking. The first thing that investors think is not, let's file as many patents as we can for the long term, because there's no long term for them. So that's one thing. And then I would say the other phenomenon is that because a lot of the unicorns in the past year and a half have been AI related, there's a less propensity to run to file patents in the AI space, for a reason that I've just mentioned, which is more, cyclical, but also for more fundamentally, because in many cases, there's no benefit if you have a AI related invention, which is usually a better algorithm than your neighbor. There's no real benefit to disclose this to the world through a patent application, and knowing full well that if someone infringes, you probably will never be able to detect the infringement, because most AI engines essentially work in a black box as a service in the cloud. So if you're not going to be able to detect, there's really no point protecting it through patents. And as a result, most of these companies prefer to treat that as trade secrets.
Have trade secrets come up in value? And you can't, of course, the trade secret, as Brian Hinman says on the CIPU board, and well known in the IP space, he says know-how is know-how and trade secret is trade secret. Trade secret you don't license. Know-how you can license. Technology licensing you could talk about. But a true trade secret, you don't even talk about it within the company.
There's always a conflation between trade secrets and know-how, because one leads to the other, and there's a category of know-how that is so important that you call this trade secret. But in reality, there's this kind of, it's a bit fluid. Trade secrets by law are something that is secret, has commercial value to the company, and for which the company has taken reasonable measure to protect the secrecy and maintain it. So the textbook example is the Coca-Cola formula. So if you put that as your kind of gold standard and you look at what you have, well, an algorithmic formula is kind of the equivalent, the AI equivalent to Coca-Cola, if you will. So that you keep in the safe, and obviously you deploy it in your services, like OpenAI does, like most AI engines do. They have algorithmic source code that's been implemented in software code and binary code that runs all these AI searches. And that is obviously very, very coveted and very important. And it gets refined all the way. And I'm pretty sure that there's a certain limited access in all these companies to who has access to these algorithmic formula. At the same time, when you're a Google or a Microsoft or a large company, the value is not simply your AI engine, but it's the installed base that is so valuable. I mean, I run AI searches all the time between 3 or 4 different services, whether it's Copilot, Anthropic, or OpenAI, or Gemini, and I get very different results. And some I think are much better than others. They have different algorithmic formula, but the fact is that they corner the market already. There's just 4 currently that are worth their salt. And even there will probably be some consolidation, or, there will be some market share that one will take over the other. And I'm not sure it's because their AI engine, it will be so much better than the other one. It might just be simply because they have so many people already consuming other services. The same reason Marketplace has taken over other classified services because people were already on Facebook. So there's this network effect at work.
I think Llama, the Facebook engine, and Gemini, the Google engine, I think they're open source.
Some aspects of it might be the same way. I think there's a open source component to OpenAI, but for the most part, I don't have access to the source code.
Not that you could do anything with it if you had it, but you could sell it. Louis, legislation and court decisions have diminished the value of many patents. We talked about this somewhat, but which industries or technologies do you think have suffered the most, in your opinion?
First, I think the people who have suffered the most are small inventors, individual inventors, small companies. So regardless of the technology area, the fact that so many of these patents end up being declared valid once they're challenged. When you have a invalidation rate of 80 to 85%, depending who you listen to, it's a 80% plus defect rate of a product called a patent from the USPTO. There's not a single industry that could get away with that except if it were the government. And here, that's why it's still happening. And then it's just a charade because you have one arm of the government charging you a lot of money to issue a patent in the first place, and another arm, which is an offspring of the first one, charging you an order of magnitude more to tell you that the patent was never valid in the first place. In any other industry, people would be in jail for doing this, but again, it's because it's government regulated and it originates from the government, people seem to get away with that. So that's the first scandal in my view. So, and it has touched mostly people who don't have the appetite or the resources, frankly, in most part, to protect their rights. So we get bombarded by inventors every day. We get about 3 or 4 portfolios every single day that people want us to help them sell. And we will only take maybe one every month. That's a rejection rate of 99% on average. That means there's only 1% of the patents in circulation, statistically, that may have some value on the secondary market. And that's because of, where we are legislatively and with the case law. And we're going back to the issue with the PTAB, and we're going back to the issue with the eligibility. There are 2 current legislations that are on the Hill. There's been about 10 bills in the last 7-8 years trying to either fix the current situation or make it even, harder for inventors to protect their right, depending who was lobbying the bills. But the 2 that are the most recent ones and have, I would say, garnered some steam, one is called Prevail, and the other one is called PARA. And I will spare you what the acronyms stand for, but Prevail is essentially a way to reform the PTAB. Currently, the PTAB is not even applying the same tests for prior art and the presumption of validity than the courts do. So if you have the same patent and you go before the courts and you go before the PTAB, you could have 2 completely contradicting decisions on this very same issue with the same prior art. That doesn't make any sense. So that's one of the many flaws of the PTAB, beside the fact that it's biased. Financial incentives for its administrative judges are such that, the more patents they invalidate, the more money they make. The incentives are just not aligned with, I think, what should be the objective of the PTAB, which was supposed to be 10 years ago, is get rid quickly and cheaply of the bad patents. Now they're getting rid of 80% of the patents, and not cheaply and not that fast.
You would think that the 20% that survive, let's assume it's 20%, that they're licensable. They've been issued by the USPTO. They've been validated by the PTAB. So now we don't need to litigate. But no, then you start over again.
Yeah, in theory, they are licensable. In practice, if you practice the efficient infringement, you're not in the business of taking licenses, regardless of whether the patent has been battle tested and confirmed by the PTAB. So all you have, if you win the PTAB, which is a lot, is a patent now that is going to be a lot harder to invalidate in court. It's not impossible, because it sounds like people have several bites at the apple, or they might file a post-grant review on your patent if they fail on the IPR. I mean, there's so many tools we've given defendants nowadays to run the clock, so to speak, that, it may take years from time to money. And then obviously it becomes a matter of resources and funding to go out there. So unfortunately, even if they are licensable in theory, in practice, you still have to sue. You only have more leverage now in the U.S. than you did before because of the PTAB, favorable PTAB decision.
Louis, what does this mean for innovation? If you're a big tech company and you're doing R&D and there's something better that comes along that you may be infringing, you're going to neutralize it. You're going to disqualify because you're going to have to take a license or not. So it's not the best innovation always that's getting used. It's the innovation that someone controls or can profit from. What's the impact on innovation ultimately?
Well, I think long term, it's significant in a bad way. I mean, already there are a lot of people who used to be tinkering in their garage that, frankly, if they follow what's going on, should not be doing that. It's a waste of their time and resources, because if they spend 5 years in the garage coming up with something new and really useful, unless they have millions of dollars to build a company around it, which most inventors don't and don't have necessarily the skill sets to do that. They're not business people. They're thinkers. They're inventors. They're in this valley of death where unless you have a product yourself and a business that you could sell as an ongoing concern, all you have is basically a patent or many patents that people will infringe shamelessly. And if you go to them and you say, you guys infringe, you should take a license, they'll say, sue me, because we've given them so many ways out and, get out of jail free cards. And then what used to be the common phenomenon, which is the inventor would have a prototype, a working prototype, and then he would do the rounds, or she would do the rounds with, companies in that space, and someone would be interested in taking a license because they respected the value and the strength of it, and they did not want to do this illegally. Now, there's no real, obstacle, and consensus is that it's probably okay to do it because the patent is likely to be held invalid if you challenge it, and it will take years anyway for someone to go after the infringer. And after 5-7 years, all they're going to have to pay if they lose is what they would have paid in the first place 5-7 years before. So there's no incentive for anyone to have a good faith negotiation with an inventor and licensing their invention, which is very unfortunate. I think it goes to the crux of the innovation engine in America, which has really been what distinguished the U.S. from a lot of other countries, was this innovation engine, because everybody was basically thinking of coming up with something new and protecting it by patent, because there was an assumption that they would be rewarded for their contribution. Now that's gone.
Some people call the efficient infringement predatory infringement. It's efficient for shareholders, perhaps, and companies, big companies largely, not always, but it's not efficient ultimately for innovation. It's really kind of disruptive in a negative way.
And it's predatory in a sense. I think a lot of the infringement by large companies is innocent at first, in the sense that, and I've been at Microsoft for 15 years, I know how large companies work. There's usually a memo that tells people don't look at third-party patents because we don't want to be in a situation of willful infringement. So people are flying blind for the most part and reinventing what others have done in many, many cases. And then they're being told that they infringed because they reinvented the same darn wheel. So the predatory aspect is not in terms of going out and looking for something useful and then they'll say, oh, we'll copy it. They actually, in most cases, come up with the same invention, but years after someone else had been there. But the predatory aspect is when they decide that they're going to use the system to essentially not recognize other people's IP rights. And that's the part that is really detrimental to the U.S. economy. And we've seen already a lot of metrics showing that the money is flowing to China and Europe because people don't trust the U.S. patent system anymore.
I write this IP Close-Up blog, and I had 120,000 visits on the Robert Kearns invention, the film Flash of Genius. And people send me comments all the time at, look how terrible that was. It was just on the intermittent windshield wiper, as you know, that Ford developed first. It's a movie that's really quite interesting called Flash of Genius. They say, oh, that's so terrible. It destroyed him. It destroyed his family, which is all true. It did. That could never happen again, could it? I said, no, it happens all the time. It's worse today. And I don't think people get that. That was 35 years ago.
It used to be the exception. Now it's the rule. 35 years ago, we were in the first years of the federal circuit. So I believe it was a good time to be a patent holder. You had injunctions. That was before eBay, damages. You didn't have all these cases of, smallest sellable unit and all these damages related cases that, essentially emasculated recuperable damages to a very small amount. If there was a golden era for patent assertion, that was basically, from the mid 80s to the mid 90s. And then, it started to change, or maybe I would say until probably early 2000. And then it changed, at least, 11, 12 years ago. And
with AIA.
Yeah, AIA, the American Invents Act, that created the PTAB, which frankly, I don't think people expected. I'm sure there were some Machiavellian thinking, with a few people in the industry, but for the most part, I don't think people saw this coming and thought that they would have the impact it had. If anybody had said the PTAB will invalidate 80% plus of the patent reviews, I think people would have said, well, what are you smoking? But that's unfortunately where we are now and where we've been for years. It's been fairly, consistent over the years.
It's not so much, it seems to me, patent weakness or weakness in the IP system, but the dysfunction is from uncertainty. I think if there was more certainty earlier on with regard to patents, positive uncertainty and negative, some patents shouldn't be issued and maybe they are weak, but we should know about it sooner, not take 5-10 years and $10 million to figure that out.
Yeah, there are definitely patents that should never have been issued. And we see those all the time. I review all these portfolios every day, and I think we're doing people a great disservice by issuing patents just because they're sympathetic inventors and they want to have what we call a vanity patent, and then they want to go around sell it thinking it's worth millions of dollars. There are a lot of these inventions that are not true inventions, because they're obvious, or they are abstract, very, very abstract. It's just a concept and there's nothing behind it. But having said that, and yes, we should probably be a little bit, tightening the screw a little bit on what gets issued. But even if we did, and let's say there were 25% fewer patents issued, the fact that we had an 80% invalidation rate tells you that the problem is not necessarily with the quality of the patent, but the problem is with the agenda of the PTAB and the incentives that are misaligned with what was supposed to be the objective at first. We've had patents that were licensed by industry players that were infringed, that we essentially, try to sell, and eventually, instead of selling, our client went for assertion and either got their patents validated by the PTAB on very spurious arguments, but then you're stuck with an appeal that is very unlikely to succeed because the federal circuit hates to do that, and it's expensive. We had a case where we had a really good group of patents that had been licensed by industry players who know that you wouldn't take a license, especially nowadays, without knowing that these patents were really, really good. And yet, when we infringe and someone filed a motion to dismiss based on Alice, the judge who had just been appointed weeks before, it was his first patent case ever, sat on the motion for 1 year, and then probably at the 1 year, a week before the 1 year anniversary, before the chief judge would go and, in his office and tell him what's going on with this, he just issued a 2-page judgment saying that the patents were abstract, and then he could check that box and, dismiss the case and move on and make his quota. So, you have a lot of lazy judges, I think, for whom the Alice off-ramp as be really a boon, rid of a case.
Well, patents are intimidating, I think, to them.
I mean, it's a technical aspect that not everybody relishes, and I cannot blame them for that. The same way, some people don't like to do family law, but at the same time, when you're a judge, you have to give everybody a fair shot and a fair shake, and that's not what's happening. The same thing is happening in Texas, where depending on which judge you get, there's a judge who likes patent cases, going to do everything he can to keep them in Texas. There's another judge who hates patent cases, and he's going to transfer, to another venue at the first request without without giving the parties any chance to this, to depose the witnesses of the party asking for a venue transfer, which is a denial of justice. But again, are you going to appeal that and pay tens of thousands of dollars to go to the Federal Circuit, who hates the situation and probably will do nothing about it? That's the problem we have currently. We don't have a very well functioning legal system, unlike Europe, which is now taking over with the UPC.
While patent nuisance suits, Louis, certainly exist, there are far fewer patent trolls than the media would make them out to be. What's the potential impact of this misperception? Something that we at CIPU deal with all the time. It's gotten a little bit better, but still people think there are patent trolls coming out of the woodwork.
Yeah, I mean, we've been victim of this patent troll myth for over a decade now, because for years, the only narrative was the one paid by big tech to push this patent troll myth. And there was really no counter narrative until maybe 5 years ago, when the U.S. inventor came up, which is a small inventor lobby, and unfortunately very underfunded, well-meaning individuals who have been, frankly, doing work in the past 5 years, but, they don't have the resources to compete head-to-head with big tech. But they've done quite a good job, I think, at, convincing some representatives on the Hill, both congressmen and women and senators, about the fact that this patent troll myth is but a myth, and there's very few of them. And frankly, I sell to non-practicing entities all the time. The amount of scrutiny and the thoroughness that they put into acquiring patents is actually much higher than operating companies. And they only take, buy the highest grade patents that have absolutely no flaws, and there's very few of those. So for me to then say, oh, these are patent trolls, and they're bringing a lawsuit that is ridiculous against, defendants, no, it doesn't exist. I mean, yeah, you're probably going to have, and we know we read in the press, there's still a couple of actors out there who will just file hundreds and hundreds of claims and do nuisance. But, it's like any industry. There's always an outlier or two that, muddies the water for the rest of the industry. But for the most part, the non-practicing entities that we know, and they're not that many, do an extremely rigorous, work and due diligence. So, I would never think that anything they acquire and that gets asserted would be deemed to be, frivolous or a nuisance or attract a nuisance type settlement. I mean, a nuisance is in the eye of a beholder. If you take a lower settlement pre-litigation because you made the calculation that it's better for you and your client to do that now than to fight and, pay $5 million to get 3 at the end, it's not a nuisance basis. It's just based on the rationale and the economics of litigation in the U.S.
Louis, we're running low on time, but I want to ask a couple more questions. R&D appears to be a highly inefficient way to obtain patents that a business needs. I mean, you can do a little R&D and file a lot of patent applications for an invention, but in licensing and acquiring patents seems to make more sense, seems to be more efficient. You get what you need when you need it. What's your thinking?
This is the kind of underlying premise that you cannot build everything you need the same way you don't need everything you build. That's the underlying assumption of what we call open innovation. So normally, and we know how long it takes and how expensive it is to build a patent portfolio organically. It takes a decade, before you have 10 patents even. So imagine hundreds. So the logical thing would be to find it on the market and then just choose what you need. And there are many patents in circulation. But again, it's like the real estate market, or part that you need to build something. When you buy a house or you build a house, there's some things that you can provide yourself, but you're going to need to buy a lot of things left and right. Well, if you're not sure whether these parts are valid and will ultimately sustain scrutiny, then it basically creates a cloud over every transaction. That's why it's so hard to transact patents. It's basically the doubt over validity for the most part. If we just imagine we have this cloud in real estate transactions where you buy a house and you're never quite sure whether the seller has the right title and is a real owner, or that the ground that it's built on is really has the same owner. I mean, all transaction would come to a crawl overnight, because people will say, wait a minute, I'm not going to buy a house without knowing that I actually own it and that it's going to be mine in 10 years. So that's the problem with patents. Take that away and you have a fully liquid market, but we're not there yet, and we won't be until we reestablish the presumption of validity that people actually believe in.
2 thoughts you'd like to leave with people today?
Well, maybe one. Remember that patents are good for 20 years, and we've been through a lot of cycles in the past 20 years where patents were very high and then very low and then a little bit higher and a little bit lower. So don't get discouraged by the current landscape, because first, I think it's improving. I'm optimistic about what's going on also on the Hill, because there's pressure from around the world that makes all this almost inevitable, that they have to restore patent rights in the U.S., because now they're seeing the impact. It's going to be too little too late, but at least it will be something. So I would tell people, don't stop filing patents because currently the market sucks. In 20 years, or 15 years or 10 years, it might be quite different. So you have to take the long-term view. And yes, I think you have to look at what's already there before you start reinventing the wheel, which too many people still do.
Great. Louis, thank you so much for this. This has been really enlightening. As always, you're on the front lines. You're like the soldier, in the war. And you've given us a lot to think about. And we'll have to have you back on again next year.
Okay, Bruce, always my pleasure. You take care.
Understanding IP Matters is brought to you by the nonprofit Center for Intellectual Property Understanding, with the generous support of its partners and sponsors. Gain access to all 4 seasons by subscribing for free on your favorite platform, or email us at explore.understandingip.org. Content conveyed is for informational purposes only and does not represent the views of CIPU or its affiliates. This episode was produced by Jack Shields for Wild Creek Studios. Thank you for listening.